Hey, you're listening to Cracking the Code, the podcast for leaders building and growing service-based businesses. If you are in legal or medical or financial services, if you have letters behind your name that qualify you to do what you do for a living, you are in the right place. I am your host, Rob Riggs, here to bring you intel and access that are designed to decode how technology can be and should be impacting your growth. All right, let's get into it. All right, thanks for tuning in again to Cracking the Code. I'm Rob Riggs, and today we're talking with Devin Miller, founder of Miller IP Law. Now, if you've ever wondered if you've actually needed a patent or if you've ever Googled your business name only to find someone else has trademarked it 3 years ago, then this conversation could be interesting for you. Devin, thanks so much for joining me. And why don't you take a minute and tell us about yourself?
Yeah, I'll take just a minute. That's a whole long conversation if we wanted it to be. Probably not what's intended, but no, just to give the short background. So, Devin Miller, owner and founder of Miller IP Law, provide a lot of patent and trademark services for startups and small businesses. Real quick background on myself. So I got 4 degrees, which my wife always jokes is 3 degrees too many. So I got an electrical engineering degree, Mandarin Chinese, an MBA, as well as a law degree. And then I've always both done startups or done my own startups and small businesses. Love doing that side of entrepreneurship, as well as been a full-time attorney working with startups and small businesses. Been married for 17, almost 18 years, have 4 kids, ages 10 to 15. I run about 9 to 12 miles a day and bike anywhere from 30 to 40 miles a day, other than Sundays. So that's the real quick walkthrough and a little bit of introduction on myself.
I appreciate the surface level deep dive. Really cool. I've found a lot of IP attorneys have like a technical or engineering background, and so that no surprise there. But Mandarin, can you talk to us about that for a second?
Yeah, and just as a really quick aside, so you'd have to. So if you want to be a patent attorney, you get to sit for a second special bar, which is called the patent bar. To be eligible for that, you have to have a technical undergraduate or graduate. So it's either engineering, math, physics are usually the ones that qualify. But Mandarin Chinese on the other side. So I served a religious mission for my church, Church of Jesus Christ of Latter-day Saints, nicknamed Mormons, and it was in Taiwan. So I lived there for a couple of years doing a religious mission. So I initially learned it and picked it up there, and then just when I came back after that, I added it on as a second degree while I was studying electrical engineering.
Super cool. I don't meet many native English speakers who also have proficiency in Mandarin, so that's pretty cool. Um, so can you talk to us about like what got you into the law side of engineering?
Um, I mean, I don't know if I have a grandiose, just amazing story. I mean, really, the story that I usually tell, which is true, is I got towards the end of engineering and decided I didn't want to be an engineer. More so in the sense that, not that I don't like engineering, but a typical engineering to graduate, you're a very small cog in a big wheel. It takes a long time to work or work your way up to having any real say or direction or input as to what you're working on. And it's usually are on a single project for a long period of time. So none of those really sounded enticing to me. And so it's kind of exploring alternatives. And really, I got into, well, I find, I'm interested in doing a startup or a small business. I also find the variety and the legal side of things to be interesting. And so that's where I did both the MBA as well as the intellectual property, because it gives a mixture of utilizing the engineering background, working with a lot of other startups and small businesses on cool things. And really from there, it just kind of naturally evolved to pursuing both over the course of my career.
Love that. So yeah, and you get to see some pretty cool stuff before it hits market. You know what I imagine. So a lot of our audience are professional services. They sell B2B, or they sell their knowledge, for a living. They have letters behind their name that qualify them to do what they do. But beyond SaaS or tech or like trademarking, something, what generally should somebody be looking for when they're considering kind of their IP?
Yeah, so you hit on the predominance. So most of just as a really quick overview for the audience, IP is there's three things. It's an umbrella term that includes patents for innovations. It includes trademarks for branding, copyrights for creatives. So pictures, images, videos, those type of things are fall under creatives. So that's going to, most companies, whether even if you're in the service-based business, as an example, you still have a brand, whether you're a, doctor, chiropractic, health services, Coke or Coke, Pepsi, anything, you're going to have a brand that you're working to establish and get a reputation. So predominantly, you'll still fall under a brand. Certainly if you do have technology aspects, if you're integrating SaaS, if you're working on an innovation, you're doing something that or improves on a technology user, you innovate something new, going to fall under patents. If you're going outside of that, in other words, you're saying what if either you don't qualify, you're not interested, or don't really have anything that is covered there, most of it's going to be more just on making sure that you have, as an example, contracts lined up. So if you're working with, patients, and you're going to make sure that it's clearly outlined what are, patient confidentiality, what are those waivers, what are the intake processes and forms that they sign. And a lot of those are going to be reasonably standard across the industry, and then customized to your specific nature, your specific services. Then the other one that sometimes people oftentimes will kind of give very little attention to, but it can often be more impactful, is going to be more on either employment agreements and or independent contractor agreements. So a lot of times people say, hey, it's great, I'll just hire good people, pay them if they leave, no big deal. But in the process, they may be exposed to things that processes that you do behind. They may be exposed to client lists, or they may be exposed to something proprietary or information or ways that you do things. And so, to the degree, depending on the state you're living in and what they allow you to cover, a lot of times that's an area that can give you additional protection that people oftentimes overlook.
Yeah. So interesting. So you're touching on kind of the blend of what is state law, like employment, and then what might be more national, which I would expect to be IP, right? Do you have a general rule of thumb for where you cross over and where you kind of avoid getting involved?
So I really primarily focus on IP. So I'll do some state law stuff. Mostly it's just going to be if it's sometimes a cease and desist letter. It sometimes is contractual, mostly business in nature. But I'd say 95% of the predominance of what we do is going to be on the federal level. So patents, trademarks, and copyrights, and focusing much more on that intellectual property front is the predominance of our focus. The drawback to that is state law. You can only, as opposed to if you're on the federal law, if you're doing intellectual property, we have clients, if not in all 50 states, pretty close, and we can, we are set up to do everything, remotely. So we do everything via phone or Zoom, or I always welcome people to come into my office, but by no means do they need to. And so it gives you a much broader ability to provide services across the board to a lot of our people across, the whole U.S., as opposed to if you go to the state law level, then you're really limited to wherever you're licensed or the attorneys in your office are licensed to. And so you have to niche down that way. So really, I tend to focus on wanting to have clients in as many locations as I can.
Sure. That makes sense. Can you talk about how so your best clients are think of their IP as a business asset for as they certainly as they're building valuation, if there's a sale coming up in the future where there's an exit, are there other areas where IP kind of serves as to build value in a business?
Well, I mean, you can look at it as one, or you hit on one, two different things. One is it's more defensive, and one of it's more offensive. So, yes, if you're making an exit, you're selling it, you're turning over the brand, turning over the business, bringing in partners, bringing in investors, whatever that might be, then they're going to be investing in the brand. Now that is an asset of the business, but what makes it an asset is also what makes it defensive, right? In other words, what you're really doing is you're carving out a portion of the industry that people can, as an example, use your brand. So when you think of Coca-Cola, or Coke or Pepsi or M&Ms or Apple or Nike, you think of one brand, right? One brand comes to mind. And I can guarantee if you go out and you put a soda or soda drink out there and call it Coke, you're going to get in major legal trouble because you've now just walked over and infringed on Coca-Cola's trademarks. Same thing, even if it's at a smaller level, it may not be that you're a national brand or the size is entirely name recognizable. But if you are starting to get a good reputation, you get good reviews, get online presence, you have something you're offering that's unique, you have great customer service, whatever that might be, and somebody says, great, you've done all that work. Now I'm going to do something that is the identical name or branding or mimics it or otherwise rides those coattails. Then you have the ability to go out and stop someone from doing that. Well, really, you have to have that intellectual property in place. And waiting until that already happens is the worst case, as far as when you can wait to have that. In other words, if you wait till there's already a competitor that's already using it and you haven't registered anything, and even worse, if they have now filed for something before you are in the worst position of being able to do anything about it and having a much more limited ability to do something if you have any options. And so one is, claiming it as an asset, but the asset is really only as good as the value you drive into it and then the ability to defend it.
Sure. So you brought up an interesting point. If somebody has missed out on kind of trademarking something, they find something, say somebody else using it, or something close to it that infringes. Is there kind of like right of like first use? Can you, if you proved you were using this 10 years ago, is that part of what you kind of help prove? Or if somebody files first, do they get basically ownership of that trademark?
Filing first is always the best. I mean, it's kind of like in football. You throw a Hail Mary if you have to. There are some very limited rights that are called common law rights, being the first person in the marketplace using a brand. I never recommend trying to rely on those because they are significantly harder, more expensive, and much less effective in actually asserting. The way that they generally work is if you are truly the first person to be using a brand in a given location, you can continue to use it, and then somebody else comes along, files for a trademark later, or just starts using it in other locations. What it really does is you are now locked into only having the ability to continue to use that brand in your current geographic locations prior to the other person filing for the trademark. So to give you an example, I come up with the world's best deep dish pizza. I'm in Chicago and I name it ABC Pizza. First person to use it. And I've been doing it for 50 years. And somebody else says, hey, either they see your brand or independently, they file a trademark for ABC Pizza. Well, they now own the trademark for ABC Pizza for everywhere across the US except for Chicago. You own it to use it in Chicago. Basically, you can keep using it in Chicago. You can never use it anywhere else. And the other person has rights to use it everywhere else except for Chicago. And it can get even more dicey. Let's say that really it's not Chicago, but let's say all of your sales are within a 5-block radius, then you're limited to a 5-block radius. And so you can't even open up a second location. You can't franchise. You can't do any of those things. And so there are very limited rights, but unless you're just okay with saying, hey, I just want to be at the single location. I never intend to move. I never intend to do a second location franchise, never intend to brand in any way, then you can maybe be okay.
Yeah, interesting. So how about protecting beyond the U.S. borders, let's say? Is there anything you can do to protect somebody in another country from grabbing your IP, your trademark, whatever, and using it over there, and eventually trying to infiltrate the U.S. border? Any thoughts on that? Do you get involved in that at all?
Yeah, yes. We have clients both that are outside the U.S. coming into the U.S. that we help, as well as clients that are in the U.S. So we help to go outside the U.S. So pretty familiar with it. I mean, the shortest answer is you only have protection for where you file it, for whether it's patents, trademarks, or copyrights. You don't have a worldwide or an international patent or something. You just file in one place and it gives you worldwide rights. Biggest brands, say, take this as an anecdote. When you came out with the Apple Watch, do you know why they named it Apple Watch as opposed to iWatch?
Did the iWatch already exist somewhere?
So in China, there was already a small company that was named or had the trademark for iWatch just in China. Apple tried to negotiate with them, didn't go through, it didn't work out, and so Apple, as opposed to they have the iPhone, the iPad, everything else is named they didn't want to have to split their brand and have the iWatch and everywhere but China and have to do entirely different packaging and branding for China. And so they came out with the Apple Watch. Now, they may have since resolved that, but at least at the initial onset when they introduced it, as big as they were, they hadn't otherwise filed for it or weren't able to get a trademark for iWatch in China. So they had to go with a different brand worldwide. And so, same thing here. If you're really, you need to look at it not as I want to own it worldwide. If really you're looking at it and saying, all of my business, all of my plans, the next 50 years that I look out are all going to be really within the US. I'm a service-based business or even a product-based business, and I'm just going to be predominantly in the US. I wouldn't worry about outside the US because it doesn't really matter. You don't have customers, clients, you're not going to be doing any activities in there to invest in or to file into those other countries. It doesn't make sense. Vice versa, like as an example, we have some medical device clients that EU is another big marketplace for a lot of what they do. And so they'll file for intellectual property here in the US, and they'll also file for it in the EU. So, it really more depends on where your customers are at and where you are doing business as to where you'd want to have protection, not just in, other countries that you don't care about.
For sure. Okay.
Hey, this is Rob Riggs, and I wanted to take just a second to tell you about Code Conspirators, our sponsor here. And we are a technology-focused performance marketing agency serving professional service firms. So that's legal, medical, financial, engineering. If you have to take a test to do what you do for a living, we help you grow your practice with websites and apps and software and performance marketing. That's organic, paid ads, retargeting, conversion optimization. And we're also doing a whole host of things with CRM, AI, and automation that's been bringing our clients tremendous value. If you're curious at all, go to codeconspirators.com to learn more. Now back to the show.
Okay, and it makes sense and always good. We want to be planning out as far as we can into the future, but 50 years into the future is a bit difficult to predict where business is going to go, right? So I see that being a challenge, and better off, just protecting as you go along, right? So are there, nuggets of advice that you give people who are considering do I need to protect this? Is the answer always yes, or how do you vet when it's worth reaching out to somebody like yourself?
Yeah, there isn't a hard and fast, one size fits all rule for everybody. There's a couple maybe rules of thumb that I would consider. One is, have you built it to the point where you've actually find any value in it? So in other words, if all you do is have an idea or you have an inclination as to, hey, I might want to do something about this, and you put in zero investment, no real, time and money into it, you're probably too early stage. You can, it's fine. It's not a bad thing, but if you really haven't done it, then I would, if it were me, I would be putting the time and money initially into, actually starting to build something that has value. So you have something, you're capturing value for something you've already built, as opposed to the opposite of going or trying to capture that before you have any value to it.
Sure, okay.
Always driven by budgets. In other words, if you don't have the budget for it, if you don't have a business that's making money, it doesn't make sense to invest in intellectual property. So,
Sure.
if it doesn't mean that you need to wait until you're a huge company, have tons of revenue, and you may be way too far down the road and saying, hey, I should have done this years ago, and I just kind of kept pushing it off. That's not a good place either, because half the time then you're miss the window for trademarks, or on the patent front, you've already, if you have put something out in the public for more than a year, then you have missed a window to even file a patent. So if you have a product, something new, innovative that you put out, and it's been out in the public, whether you're offering it for sale, putting it on a website, white papers, anything else, and it's been out for more than a year, you've lost that window. You can't file for it. There's a year limitation. So there is a balance of finding the right time. The best rule of thumb is kind of what I'll call the ouch factor, which is basically if somebody else were to come along and knock off your product or knock off your brand, If you're saying, yeah, that's not fun, but hey, I don't, it wouldn't be that big of a deal or that big of an effort to rebrand or to adjust things or to do something different. You probably haven't done enough to capture any value because it's, really doesn't have an ouch to the business. If on the other hand, you're saying, oh no, that'd be terrible. If I had to go and rebrand, then here's all the inherent costs that I'd have to go and redo the website, redo our packaging, redoing all of our, online presence, redoing all the information to our clients, redoing our reputation. You built a lot of value into it, then you should be wanting to capture that. So you kind of have to look and say, if you had to, if somebody to come along or knock you off, wouldn't matter.
Sure. Okay. Nice. Let's see here. The proliferation of AI in the world today, in the business market specifically, how do the IP courts look on the co-creation of value, of content, etc. That I've entered into ChatGPT or Manus or whatever? Does method of creation matter or impact at all, in terms of who owns the rights?
Sure. Courts really are too slow to catch up yet. In other words, I'll give you a better answer, but the fairest answer is law is just a really slow moving thing. It is not made to evolve or to move at a fast pace. And so something that takes place in the marketplace, it takes a long time for the courts to catch up and actually start to make decisions about it. So to a degree, that's still the Wild West in some aspects. Now, in reality, if you're saying, hey, I went into ChatGPT as an example, and I had it create me a logo, or I utilized it to refine a idea for an invention that now I'm pursuing, but it was, it gave me some feedback or an assistance tool. They're still looking at it as you are the creator. So whether you're putting in the prompt or telling it what to do or how to do it or to modify or adjust it, excluding if you're using other people's material to do that. In other words, if you're saying, hey, here's a logo that I really like that's going to infringe on someone else's, change the color slightly and modify it a little bit. You still can have an issue with you're using someone else's logo, and just because you happen to run it through AI doesn't obviate that. But if it does create something new or unique, at least for now, they're really looking at it as you're still the individual that provided the prompts or came up with the idea, told AI what to do. At least at this point, it's not sentient. It's not doing things on its own without some degree of input or direction. And so they're just saying it's no different than a tool that you're using to assist you in doing whatever activity you're doing.
Sure, super fun. And on that note, where do you think your industry is headed in the next 5 to 10 years?
You're saying with regards to AI or just the industry in general?
Just in general, where are you seeing, kind of how are you planning your future, your near future?
I'm planning to retire the next 5 years, so I don't have to worry about my future. Assuming that doesn't happen, I mean, AI is going to impact, I think, the most near term, and it's not certain. I don't know that anybody knows, and anybody that claims to know is probably lying to you. But it has right now. AI, a couple of things. So in the legal industry in general, it is certainly, whether or not it should is a different story. It is making inroads or becoming more as a tool that are utilizing. So people will go anytime they have a legal problem or they want a legal document, they'll just go to AI and throw it in there and it'll spit out something. Now, the problem that people have, one is they don't even know how AI works. So they have no idea if AI is doing an awesome legal job and everything that it says is entirely correct, or it's feeding you a whole bunch of garbage. And, if you don't have the background experience to know how to sift through the difference, all you're getting is a document that's split out from AI. And it's a wide variety of what you're asking it to do as to how good it's spitting something out. If it is a simple question that is something that's asked over and over repeatedly on the internet, it's going to give you a decent answer. If you're asking it to draft a complex document, like if I were to go and ask it to draft, as an example, a patent, at least at the current stage, it's garbage in, garbage out. It really doesn't do a good job, and you're better off to just simply draft it yourself rather than have AI do it. But with that said, I said part of the problem is people it's kind of like Google back in the day. I used to Google something. I can explain to you. I have a lot more technical background and familiarity, both with what I do and just as a technical background. If I were to go ask my wife, how does Google work? I don't know. I ask it to search for something and it gives me results, and I trust that it probably knows what it's doing, and that trust is inherently transferred to, I think, to a large degree over to AI. And so there's an inherent trust that probably isn't earned and presents a large amount of issues. But with that said, it's still there. People are still using it and trusting it. And so attorneys are trying to figure out, one, how can we leverage it as a tool within our practices? So, can I utilize it to maybe not get me 100% of the way, but to shave several hours off of drafting a document or doing some initial review or doing some initial checking to make sure things are in place? You can do that to a degree. You want a whole cloth turn it over. So I think in the short term, that's probably where it's headed. The other interesting thing is kind of on the flip side, and more specifically, typically more on the patent side, it is short term, and I don't see as long term, is probably prompting more people to pursue patents because it's giving people, hey, I have this idea, I really don't have a technical background or understanding of how I'd approach it. I'll go ask AI, and it can give me at least a starting ground or an idea as to how I might approach that. And I'm going to start a business where I wouldn't really know how to even approach that or tackle that several years ago. So that would be one where there is one where it's probably very short term, prompting a bit of a increase in patents, but in the long run, I think it's going to iterate as a tool. If it gets good enough, probably in the long run continues in the trend or direction is trending. Same thing with everybody else in the service-based industry. You're probably going to have to figure out how to utilize it and hope that it doesn't replace you. And if it replaces everybody, then we've got a very big displacement. All the services, or most of these service-based economy is going to have to figure out what they're going to do.
Right, how they're going to spend their days. Yeah, for sure. Devin, I know we're coming up on into time here, but is there anything you wish we had covered that we just haven't had time to yet?
I am sure there are plenty of things that I could go on for hours, and I would find them interesting sure. Talking through it, and your audience would be like, okay, that's enough. I'm already overwhelmed. I'm already drinking from a fire hose. But no, I think that covers a pretty good front, of things. And, I'm happy to share how people can reach out to me and grab a free consult if that makes sense, or I can hold off on that. That's probably the only other thing is, this is all kind of general guidelines, are higher level, not specific to any given business. And there's always a bit of customization and strategies that goes into any given business.
Sure. And so if somebody was curious about, do I even have something to move forward with, where could they reach out and learn more, or some resources about IP in general?
Yeah, so a couple things. So I'll give a few ways that you can reach out to me. Easiest thing, if you just have a few questions, we offer free initial 15, 20-minute consultations. It's not going to answer everything or get all your issues taken care of, but it gives you at least a basis to get an initial understanding and a place to start. To grab some time for that free consult, they can just go to strategymeeting.com. Easiest way to grab some time on my calendar. Not active on most of the socials. I do quite a bit on LinkedIn. So if they do want to connect with me on LinkedIn or follow me there, you just go to meetmiller.com. And that's an easy way to connect with me on LinkedIn as well. The other one that we more recently started to do, which I enjoy, is we do a lot of YouTube shorts. They're usually 15 to 30-second videos, and they are my digital avatar. So I'm in part of the creation and direction as to what it will say and how it says it in the scripting, and then we use a digital avatar for the creation. But as YouTube shorts, it's just quick snippets, 15 to 30 seconds. It hits on a given topic or question that people often have. So if you go to the Miller IP's YouTube channel, that's an easy way to kind of get some initial or quick education as well.
Super fun. Devin, I appreciate your sharing your knowledge today here and showing up and just sharing your expertise with the audience. Thanks so much for being on.
Absolutely. Pleasure being here, and thanks for having me.
All right, that was Devin Miller from Miller IP Law. If you are a founder, a small business owner, and that conversation made you realize that you might have some IP gaps in intellectual property, head over to strategymeeting.com to grab Devin's free resources or book a strategy call. So quick thought about the conversation. IP is not just legal protection, it's a business asset, and you can leverage that to build your valuation. So at some point in the future, if you're looking to sell the intellectual property that you've collected, you've generated is absolutely an impact to the value of your business. And the founders who treat it that way from day one will avoid expensive cleanups later and build more valuable and more fundable and more saleable business. So check out strategymeeting.com. The link is in the show notes. And if you are running a professional service firm and you know your systems could be tighter, let's talk. We work with law firms and financial advisors and consultants, any service business that's ready to scale without adding chaos. Head to codeconspirators.com, book a free revenue acceleration audit, and we'll show you exactly where you're leaving money on the table. Until next time, I am Rob Riggs with Code Conspirators, and keep hustling, and we'll see you next time.